Okay. Good afternoon, everyone, and thank you all for joining us for today's presentation. My name is Marissa, an attorney with Legal Aid of North Carolina's Helpline. Today, we have Attorney Trenner presenting for us. If you are unfamiliar with the format of this event, first, Trenner is going to review a PowerPoint presentation. At the end of the presentation, we will have a question and answer session. If at any point during the presentation you have questions, you can put them in the Q&A box on Zoom or the comments section on Facebook. We'll review all questions put in the chat boxes during the Q&A session at the end. Please remember that this is a public forum and Legal Aid is not representing you at this time. Trenner will go over this in more detail, but please remember to keep your questions as general as possible, as we cannot provide any legal advice specific to your individual situation. The session will end when there are no more questions, and regardless of where we are, we will have a hard stop at 4:30 p.m. With all that being said, I'm going to pass it over to Trenner to get us started.
Good afternoon, everyone. Can you hear me okay, Marissa?
Yes.
Okay, fantastic. Good afternoon, everyone. My name is Trenner Bender. I am a staff attorney here at Legal Aid of North Carolina in our Second Chance Department. What we do here is criminal record expunctions and driver's license restoration. As Marissa mentioned, I'm going to go over a presentation at this point about criminal record expunctions. This presentation is meant to be an overview of how the expunction process works in North Carolina. I do want to remind you, as Marissa said, though I am an attorney, I am not your attorney, and this is meant to be an informational session and not to give you specific legal advice. If you are interested in getting specific legal advice for your criminal record expunction or driver's license restoration, please contact our helpline and we can look into opening a file for you so we can give you more in detail advice and representation. I think Marissa will drop that link in the chat, and I will let you know that the next open intake we have for our criminal record expunction and driver's license restoration here at the Second Chance Project will start August 4th and run through August 8th. So without anything else on that, let me go ahead and get started. Would tell you a little bit about criminal record expunctions in North Carolina. First, let me tell you a little bit more about Legal Aid as a whole. If you're not familiar with us, Legal Aid of North Carolina is a statewide nonprofit law firm. We provide free legal services for civil matters and criminal record expunctions to low-income people. Our goal is to ensure equal access to justice and remove legal barriers to economic opportunity. This Listen and Learn presentation, we offer listen and learn presentations on a number of different topics. As you can see on your screen there, we offer this one with criminal record expunction. We offer one on healthcare power of attorney, wills, and advanced directives. We offer one on benefits, Social Security, disability, SNAP, or food stamps, as many of you know them, Medicaid. We offer family law presentations on simple divorce and child custody, and we offer presentations on tenants' rights. You can see there, you can sign up for our Listen and Learn presentations on our website, and you can see our website address right there on the screen. All right, to get into the matter at hand, what is an expunction? So as you can see, expunction means to permanently remove an offense from a criminal record. Once an expunction is granted by the court, the public criminal record of the offense is destroyed. It is important to point out that, and I'll go into a little bit more detail about this later, but that once the record is expunged, though it is removed from the criminal record database systems in North Carolina, it does not necessarily mean it has been removed everywhere. There are certain entities that can still see that charge, and again, I'll go into that a little bit more detail in a few minutes. All right, in North Carolina, there are three primary types of expunctions. First, there are not guilty charges. Charges where you were found not guilty are essentially where you were charged with a crime and you appeared in court or in front of a judge and you were found to be not guilty of those charges. All not guilty charges are eligible for expunction in North Carolina with no waiting period. There are also dismissed charges. Dismissed charges are where the court decided not to proceed with charging you with something that you were initially charged with. Any charges that were dismissed by the court are also eligible to be expunged. Now, One thing that's very important to point out is that any charges that were dismissed in North Carolina after December 1st of 2021 are automatically expunged 6 months after they are dismissed. That means that you do not have to do anything additionally to get that charge off of your record. So if a charge was dismissed on December 5th of 2021, then 6 months after that dismissal, the charge will come off your record automatically without filing any further documents with the court. Now, dismissed charges that were dismissed prior to that date, prior to December 1st of 2021, do require you submit a petition to the court to expunge the charge, and the charge will not automatically be expunged from your record until you submit that paperwork. The third type of charge that can be eligible for expunction in North Carolina would be convictions. There are certain types of convictions that are eligible for expunctions and certain types of convictions that are not. So some youthful convictions, most misdemeanor convictions, and some felony convictions committed before December 1st of 2019, if you were 16 or 17 years old at the time of the offense, are eligible for expunction. And then what most people are concerned with, I find, are adult convictions. So there are certain misdemeanor and felony convictions that occurred when you were 18 years or older at the time of the offense that may be eligible for expunction in North Carolina. But this is where things can get a little bit tricky. What could prevent you from expunging your adult convictions? First and foremost, the law in North Carolina includes a list of offenses that are not eligible for expunction. If you have a conviction for any of these offenses when you were 18 years or older, you will not be eligible to expunge that offense, and it also disqualifies you from expunging any of your other adult convictions. You still may, as you can see on your screen there, you still may be able to expunge some charges that are 16 or 17 years old, but if you have been convicted of any of the following charges, then you will be ineligible to expunge that offense or any other adult convictions on your record. The list here is by no means an exhaustive list. This does not include everything. However, these are some of the things that we most commonly see that are ineligible for expunction and disqualifying offenses. Those include Class A through G felonies. These can be robbery, the sale of drugs, and tend to be violent felonies. Any Class A1 misdemeanors, such as misdemeanor child abuse, is one of the ones that we see most often. Another one is misdemeanor stalking, or occasionally domestic violence protective order violations can also be disqualifying. Any conviction that requires registration on the sex offender registry is also disqualifying. Any offense with assault as a main element of the offense is also disqualifying. Those include simple assault, assault on a female, and so on. Any offense involving heroin or crystal meth is disqualifying, including just the simple possession of that. And then also possession with the intent to sell or deliver cocaine is disqualifying. The simple possession of cocaine is not, however, disqualifying. All right, so once you have there are several steps in the expunction process that you need to go through to make sure that you complete the process correctly. If we were to open a file for you, these are the steps that we would go through to make sure that we complete your expunction process properly. The first thing that you need to do is obtain an accurate and complete copy of your criminal record. As I just discussed, because of the disqualifying offenses that can affect the eligibility of your entire record, it's very important when we look at your criminal record, or when you look at your criminal record, that it is viewed as a whole. And that's why it's so important to make sure when you get a copy of your criminal record that you have everything included on there that you may have been charged with or convicted of. In North Carolina, there are two separate criminal record databases that are used by different counties to keep track of criminal records. This is dependent on whether a county has gone to e-filing yet, or if they still use our old paper system. If some counties use what's called Cypress, CIPRS, that is one of the criminal record databases that some counties use. And then the rest of the counties use a system called Portal. Those are the counties that have gone to e-filing at this point. You can obtain criminal records from both Cypress or Portal in any courthouse in North Carolina. Any county courthouse in North Carolina will have terminals in the courthouse where you can access both of these systems. Generally, they are somewhere near the clerk of court's office. Generally, that's where you will find them. It is very important if you go to pull your own criminal record that you check both databases to be sure you are including all records that are in your name. Once you have a full and complete copy of your criminal record, you can determine the eligibility for expunction. It's important to look at what types of offenses you had and also how long ago they occurred, as there are different waiting periods for different types of offenses and different eligibility for different types of offenses. Once you have determined your eligibility for expunction, it's important to identify what form you need to use to petition the court to expunge your charges. There are different forms for each type of charge or conviction. For instance, there's one type of form for not guilty charges. There's one type of form for dismissed charges, one for the convictions that I spoke of earlier that would have occurred where the offenses occurred when you were 16 or 17 years old. And then there's one form for adult misdemeanors and one form for adult felonies. It's important that the correct charges go on the correct type of form. When you are completing those forms, there are sometimes other supporting documents that need to be filed with those forms. For instance, with adult convictions, it's important to include affidavits from yourself and 2 character affiants attesting to your good character and other elements that are required by the court. It's also sometimes important that you look to see if there is a fee associated with the petition that you are filing. Petitions for youthful and adult convictions require a filing fee, but you can petition the court to proceed as indigent, which means you can ask the court based on your income to waive the filing fee for those petitions if your income falls below a certain threshold. Now, once you've identified the correct forms, the correct petitions to use, and the correct supporting documents, you have to determine where you need to file those petitions. The expunction process in North Carolina is county specific and also venue specific. What that means is if you have criminal charges in different counties, you will need to file those charges in the corresponding county where either the dismissal or conviction occurred, and also the correct venue. Meaning, let's say, I'm in Wake County right now. If I had a criminal charge that was dismissed in Wake County District Court and also charges that were dismissed in Wake County Superior Court, I would need to file separately the dismissals in District Court and the dismissals in Superior Court. If I also had petitions in Johnston County, I would need to file those separately. If I have dismissals in Johnston County District Court, I would file those there, Superior Court there. Same with convictions. So not only do the petitions need to be filed with the correct forms for that charge, but they need to be filed in the correct place where the charges occurred. It's also very important to determine if the county has county-specific procedures for filing expunction petitions. Some counties require you to file petitions in a certain way, or to send them by mail or do them electronically. The very best way to find out what the county-specific procedures are for filing an expunction petition would be to call the clerk of court's office and ask them if they have any specific procedures that they ask that you follow to file the petitions correctly in their county. Finally, once your petitions have been filed and the court has made a decision on those petitions, if your expunctions have been granted, it's important to verify those expunctions. What you would do to verify that the expunction process has been completed would be to go back to the original place where you found the criminal record and check to see that it is no longer there. it's important to do that again in both of the databases where you originally found your criminal charges. Now, as I referred to earlier, there are certain entities who still have access to your expunged records. Those entities include prosecutors can still see expunged charges for the sake of sentencing in any future criminal cases that you may be encountering in court. Arresting agencies can also still see the records of expunged charges, and so can law enforcement. I will mention that almost all the time, after a charge has been expunged, you are within your rights to say that the charge never occurred. However, there are certain types of applications and job applications, or also licensing boards, who will ask you specifically to disclose charges that have been expunged from your record. And if you are asked to do that in an application or licensing situation, you are required at that point to disclose those charges if you were specifically asked to do so. So I know that that's kind of a general overview, and I know that you'll have questions. And so if any of you would like to ask questions at this time, please go ahead and do so, and Marissa will let me know about them.
Okay, perfect. As stated earlier, if you have a question, you do need to either type it in the Q&A box in Zoom or the comments section on Facebook. You cannot unmute in this forum. And so we'll just hop right in. First question, how can I access the question is, how can I access the misdemeanors that do not qualify for expunction? I think they're asking, how can they tell if, where can they go to find whether or not a charge qualifies for expunction? I think is the question.
Okay. What I would recommend is if you believe that you will qualify for legal aid services, or even if you don't, because sometimes that can be tricky, I would recommend trying to contact a lawyer to determine your expunction eligibility. Again, we do that here at Legal Aid, and our next intake will open up on August 4th and run through August 8th. The reason that I say that is there are a lot of intertwined pieces that you have to look at. It depends on the amount of charges that you have and how long it's been since you were convicted of those charges, how long your sentence was, how many years it's been since the end of your sentence. And those requirements change based on the totality of your criminal record. It can become very confusing, and it is really best to contact an attorney, particularly because in North Carolina at this point, expunging convictions can be a one-shot process. So you really need to try, if you're going to expunge your convictions, to include everything that can be expunged in your first try, to make sure that you get everything and it does not become disqualified in the future.
Okay.
So again, to recap, it's best to try to contact an attorney to determine your specific expunction eligibility.
Perfect. I think someone's asking, do they have to obtain their own complete record, their own copy of their criminal record, if they don't have an attorney? And if they do have an attorney, or maybe they're able to get assistance from legal aid, are they expected to come with their own copy of their criminal record, or is that something an attorney could do for them?
If you are trying to undertake the expunction process on your own, then yes, you would have to obtain your own copy of your criminal record. If you have an attorney, or certainly if legal aid becomes your attorney, you would not be asked to obtain your own criminal record. That would be something that the attorney would do for you. At least I don't know that I can speak for other attorneys, but I know that Legal Aid of North Carolina, if you were to become our client, will absolutely obtain a full copy of your criminal record for you. You would not have to do that yourself.
Perfect. Someone they live in a different state, but they're trying to get something expunged from North Carolina. Do they have to come to North Carolina to take advantage of the expunction process for a North Carolina charge?
That is a great question. We have dealt with clients that are out of state, and I think that is often one of the reasons that clients will contact us, is because they are out of state and cannot come to North Carolina, and they need an attorney to work on their behalf to do that. If you were doing it on your own, it is not necessarily necessary to come to North Carolina. However, in certain cases, a court will request a hearing on your expunction petition, particularly for convictions. And at that point, you may be required to come to the hearing. In our practice, if the court requested a hearing, we would attend that hearing for you.
Perfect. Can something that is for deferred prosecution be expunged? How is that viewed? Is that viewed as a dismissed charge? Is that viewed as a guilty charge? What happens with deferred prosecutions?
Okay, that's also a great question. Deferred prosecutions, if the way that a deferred prosecution generally works is an individual will be asked to meet certain criteria by attending classes or maybe a certain waiting period of good behavior or something like that. And once all of those requirements have been met, then the charge will be dismissed. If the deferred prosecution did in fact end in a dismissal, it definitely can be expunged. However, there is a filing fee for a deferred prosecution dismissal where there is not a filing fee if a charge was dismissed and it was not pursuant to a deferred prosecution. So what you would want to do is file you would need to either pay the filing fee for the dismissal petition, or you would need to file that petition to proceed as indigent that I was speaking of earlier that asked the court to waive the filing fee.
Perfect. And I think this question kind of tags along with that,
Okay.
where someone agreed to take a class and then their charges would be dropped. That class has been completed successfully, but it's still showing up on the record. I guess the charge is still showing up. So it might be a situation where maybe that filing fee that you just spoke of hasn't been addressed yet.
Well, so okay, so if the charge occurred during dismissed charges do still show up on your record. So just because a charge is dismissed, like I've been talking about, that charge will remain on your record until it is either automatically expunged or you petition the court to expunge that charge. So just because it's dismissed does not mean you will not be able to see it until the charge is expunged. So if the charge happened after the December 1st of 2021, and it has been after 6 months and the charge was dismissed, it may still, because of the deferred prosecution, it may still be necessary to file a petition and handle the filing fee in that case. If the charge was dismissed pursuant to the deferred prosecution before that date, you definitely will have to file a petition and either pay the filing fee or have the court waive the filing fee to get that charge removed from your record.
Perfect. I think this goes along with what someone's mentioning that I guess some employers are now looking at arrest records. Can arrest records be expunged?
I'm not really sure, to be honest. I'm not really sure what they mean by arrest records or
Okay.
how employers are finding those, or and I'm not aware of a process for asking the court to expunge an arrest record. If by referring to an arrest record, if the arrest record is related to a charge that is eventually expunged, it is supposed to be removed from the records. But again, I am really not sure what this person may be referring to as an arrest record or how an employer might be accessing that. So I'm not sure that I can answer that question effectively.
I think that was perfect. Okay. I think this is more of a jurisdictional issue, so if you can't answer it, no problem there. Someone's
Understood.
saying that they have, I'm sorry?
Understood. Go ahead. I'm sorry.
Oh no, no, you're fine. Someone's saying they had charges in two different counties, I'm assuming both in North Carolina, that have both been sent to where the home county, so two charges in two different counties, and now they got sent to a different one county. I think they're asking if they file an expunction in their home county. Okay, hold on. Wait, let me try again.
You're fine.
They have two. They're asking if the two charges were sent to a third county, do they only need to file the expunction in that third county, or do they need to still file in those two separate counties?
I
I think
am
that's
not
close.
100%. Yeah, I'm not 100% sure what they mean by sent to a third county.
Yeah.
Occasionally, what we will see on a record is a probation violation out of county, meaning that someone violated their probation in one county that was related to another charge. Sometimes there are times where if we expunge the underlying charge, we can request that the county where the probation violation occurred um, then remove that probation violation, but you would have to expunge the underlying charge first, if that is in fact the situation. I am not 100% sure that is what this person is referring to, because I'm not sure what sent to the third county means.
Okay. Um, got several questions here asking about specific instances. Like someone's asking, if there was a charge maybe 30 years ago, can that be expunged? If their convictions have to do with DV, can that be expunged? They're asking about some very specific instances, and I think you can just provide a general response to all of those.
Okay. What are the like instances that
Oh,
they're
someone's
asking?
asking, someone saying they have a charge from back in 1994. Can that be expunged? The, I think it's all just dependent on what
Yeah,
the
that really just
circumstance.
depends on what the charge is. Exactly
Yeah,
like you're saying. It depends on what the particular offense is. If it's not a disqualified offense and you have met the waiting period associated with that offense, or it could be eligible, but it really is a situation where we would have to see what the specific offense was to determine if it was eligible for expulsion or
perfect. If you could just, I think it would be helpful if you could go back to that slide
not.
with those common disqualifying offenses. That might be helpful as well.
There you go.
And someone specifically asked for that. Okay, perfect. Let me go back up
And
here.
again, I want to stress when showing this slide that this is not a complete and exhaustive list. Just because something is not on here does not mean it's automatically eligible for expunction. This list kind of just shows the most common disqualifying convictions that we see on a record.
Okay.
I know that you said something about domestic violence just a second ago, and a domestic violence protective order violation is not listed on this screen, but it is disqualifying.
Oh, okay, perfect. Um, Someone's asking if you can go over what things qualify for automatic expunction.
Any dismissed charges that are dismissed by the court after the date, here we go, 12/1/2021. Anything that was dismissed after that date will be automatically expunged after 6 months.
Perfect. Someone's asking, what is the filing fee? And the ancillary part to that question, part two, is that if they're getting assistance from legal aid, will legal aid assist with that filing fee?
So that's actually a great question. The filing fee for conviction petitions is $175 for an adult conviction, and I believe $50 for the 16 or 17-year-old conviction. If you are represented by legal aid, you will not have to pay that filing fee, because representation by a legal services corporation is grounds for waiver of the filing fee with the court. So legal aid, for our legal aid expunction clients, we do submit that petition, the petition to proceed as indigent, with every petition that would require a filing fee, and it is waived.
Perfect. Would 10 charges be too much at one time? Like, is there a limit on how many things you can expunge at one time?
Okay, so there are some limits on how many things that you can expunge at one time, but it absolutely just depends on what the charges are. If none of the charges are disqualifying, it depends on, sometimes things are considered one charge for the sake of expunction if they were all disposed of, if all the convictions occurred on the same date. So as far as convictions go, it depends on if they're misdemeanors or if they're felonies, and how long it has been since you completed the end of your sentence. 10 charges is not automatically too many. It just depends on what the charges are and how long it's been since they occurred. As far as dismissals go or not guilty charges go, you can do as many of those as soon as they're done as you want to.
Someone's saying that they've been told that charges can still show up even if they've been expunged. Is that true?
So what they may be referring to is there is one thing that can occur, and what we refer to it as is a ghost record. Occasionally, once charges have been expunged, if an entity is pulling your criminal record using one of those like private databases, those private search companies, they will enter your information to look up your criminal record, and that company may be using outdated criminal record information to supply their criminal records, meaning they may have pulled all these criminal records from the internet 6 months ago, and that's what they're used. If your expunction has occurred since they pulled that criminal record, then they will be using outdated information to supply it, and that information will not reflect the expunction process. If you have gotten a charge expunged and that happens to you, and you can find out what the company is that supplied that information, you can, there is an avenue to request that company remove that record.
Someone is asking how long does the expunction process take?
That is extremely dependent on where you're filing. There are some counties that you will file your expunction petitions and they will be back in a week. There are some counties where you will file your expunction petitions and the court will not view them for a year. It really just depends on where you're filing. It is not unusual for the expunction process to take 6 months to a year from start to finish. So it is, it can take less than that, but it's important to set your expectations correctly. This is usually not an instantaneous process.
Okay. Can Class E felonies be expunged or sealed? Not sure if we know anything about sealing a record.
Well, first of all, the state of North Carolina does not seal records. So that is not something that the state of North Carolina will do. And no, Class E felonies are not eligible for expunction and they are disqualifying.
Okay. I am putting a link in the chat right now for those of you asking how to get in touch with legal aid. There is a link to our second chance criminal record expunction page. Last question here that's not about legal aid. Someone's asking, do you know of anyone in Mecklenburg County who might be able to assist with an expunction?
Well, again, if you think you might qualify for legal aid, I would try that first because we work all over the state. We help clients from all the counties in North Carolina, as long as your expunction is based in North Carolina. We cannot expunge charges outside of the state of North Carolina. We only do work in this state.
And for further clarification, do you guys work on expunging federal charges?
We do not.
Perfect. Just knew that was going to be a question.
Thank
you. I think this is another clarifying question. Someone who is out of state is just clarifying that they need to reach out for legal assistance in North Carolina for help with the North Carolina expunction, correct?
Yes, you're the attorney if you're asking for an attorney to file for documents for you in the state of North Carolina, they have to be licensed to practice in the state of North
Carolina. I think this question goes beyond the scope of what we do here, but if you can respond, by all means. Someone's asking that if they have a disqualifying charge, is it possible, or conviction, I'm assuming, is it possible to have the case about the conviction reopened and have that charge dismissed? I don't know if that's something we can answer in this form. That sounds more criminal law-y.
There is a situation where that could be possible, but that is not something we do at legal aid. And that would be something that you would need to contact a private attorney about. It is not generally a possibility, and definitely something a private attorney would have to handle.
Perfect. Well, I am not seeing any other questions at the moment. Gonna give it just a second. See if anything else pops in really quickly. Someone's asking how do you sign up for, I'm assuming you're asking how you sign up for legal aid services. As Trainer mentioned, The phone line is not going to be open, I think you said until August 4th, and they have to call
August
in, correct?
August 4th, yes. And they can use that second chance department intake that you posted in the chat.
Okay, so yes, to the person asking if you have to wait until August, you do. Our Second Chance project is not doing any intake until that August 4th date.
That's correct.
Perfect. All right, then. As I have not seen any other questions, I'm going to go ahead and say thank you to all of you for joining us, with a special thank you to Trina for presenting and for answering all of those questions. If you would like to review anything that we discussed today, we have posted a recording of today's event to our Facebook page. It will be immediately available. You can access the recording on Facebook with or without a Facebook account at www.facebook.com/legalaidnc. The recording's only going to be available for a short while, and so after that, if you need to review the recording, it will be available on Legal Aid's YouTube page. If you would like to register for one of our other Listen and Learn programs that Trina mentioned, such as tenant rights, child custody, simple divorce, Medicaid, you can do so on our website at www.legalaidnc.org/clinics. Thank you all so much. Um, the number for the Second Chance program, it is the regular Legal Aid of North Carolina's helpline number, right, Trainer? That's what they call into our helpline.
Yes, they can call into our helpline and they will get to the right person.
So I'm just gonna post that really quickly. 219-5262. Just posting it super quickly for the number, for whenever. Okay. And so I will wish everyone, like I said, a good rest of their afternoon and have a great day.